All right, we are now live and on the record for Wednesday morning civil docket for March 2nd, 2022. Mr. Peña?
Good morning, Your Honor. This is a friendly suit. That's number one on your docket. I have Mr. Roger Garcia and Ms. Lucia Thompson, as well as my client, Veronica Garcia, on screen.
Okay, that is CL 21-1450-I, Veronica Garcia versus Esperanza Romo.
Good morning, Judge. Rogelio Garcia for Ms. Romo.
Good morning, Judge. Lucy Thompson, the ad litem.
All right, and Ms. Garcia, can you hear me?
You need to unmute, Ms. Garcia. There you go.
Sorry. Yes.
Okay, can you please raise your right hand?
What?
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you may lower your hand. Okay, go ahead, Mr. Peña.
Mr. Garcia, do you want to go ahead and question her first?
That's fine. That's fine. Thank you. Ms. Garcia, can you give us your name for the record, please?
Yes, Veronica Garcia Alemán.
Now, I understand that you're the next friend in the suit that Judge Ocaña Olivares just announced on the record, and you're the next friend of these four boys, Justin Fulbright, Juan Gamboa, Larry Mancha, and Matthew Mancha. Is that correct?
Yes.
And for the record, I understand that Justin Fulbright is 13 years old, born on December 24th, 2008. Juan Gamboa is 7 years old, born on June 2nd, 2014. Larry Mancha is 6 years old, born on October 5th, 2015. And Matthew Mancha is 5, born on November 3rd, 2016. Is that correct?
Yes.
Your boys were involved in an accident in McAllen, Texas on June 2nd, 2020. Is that correct?
Yes.
They sustained soft tissue injuries and were treated for those injuries immediately thereafter. Is that correct?
Yes.
All four boys have fully recovered from the injuries they sustained in the subject accident. Would you agree?
Yes, sir.
Now, I understand that each of your boys' proposed settlement that is before the court is for $3,000. Would that be accurate?
Yes.
Now, there is going to be some disbursement, and I'm going to break them down for you to see if these are accurate. For Justin Fulbright, there is a $3,000 settlement, as I mentioned. $1,712.27 will be to pay legal expenses and medical bills. The balance of $1,287.73 will be deposited into the court's registry. Is that correct?
Yes.
Now, pertaining to Juan Gamboa, medical fees and legal expenses will be paid with the amount of $1,830.06, with a balance of $1,169.94 being deposited into the court's registry. Is that accurate?
Yes.
For Larry Mancha, $1,512.13 will be used to pay any outstanding medical bills as well as legal expenses, with the balance of $1,487.87 to be deposited into the court's registry. Is that accurate?
Yes.
Is that correct? Okay. And as far as Mateo, my understanding is that $1,541.63 will be used to pay any outstanding medical bills and legal expenses, with a balance of $1,458.37 to be deposited into the court's registry. Is that accurate?
Yes.
Okay. Do you understand that the amount being deposited into the court's registry for each of these boys will be kept in deposit until they turn, until they each turn the age of 18, or there is a court order that would allow them to withdraw earlier than that? Are you aware of that?
Yes, I am.
And even though you have a right to proceed to a jury trial, at this juncture, you prefer to move forward and ask the court to approve settlement, waiving a jury trial. Would that be correct?
Yes, sir.
Do you understand that a document that I have sent to your attorney, Mr. Peña, titled Settlement Agreement and Release, once that is executed, will dismiss my client from any additional claims or any future funds to be paid? Are you aware of that?
Yes, I am.
And do you believe this is a fair and just settlement pertaining to your children?
Yes.
And is it in the best interest of of Justin Fulbright, Juan Gamboa, Larry Mancha, and Mateo Mancha for Judge Eugenio Olivares to approve settlement.
Yes.
Ms. Garcia, that's all I have for you, and I'll pass it to you as a witness. Thank you, Judge.
Okay, Mr. Peña, do you have any questions of the witness?
Just one or two, Your Honor.
Sure, go ahead.
Ms. Garcia, were you satisfied with the work from our office?
Yes, sir.
Okay. And now you understand, as Mr. Garcia had explained, that once the court accepts, if the court accepts the settlement offers, there's nothing we're going to be able to do, you or your children in the future, if there's anything wrong with them that you might attribute to this accident?
Yes, I
You
do.
understand that? And so
Yeah.
we won't be able to go against Miss Esperanza Roma or her insurance company in the future.
Yes.
Okay. With that understanding, you still would like to go forward and ask the judge to approve this settlement?
Yes.
Okay, thank you. No other questions, Your Honor.
Okay, Ms. Thompson, do you have any questions?
Just a couple, Your Honor.
Go ahead.
Mrs. Garcia.
Yes.
When I met with you and your 4 children, you indicated that the injuries that they sustained as a result of the accident were minor and that the injuries have since resolved. They are no longer experiencing any pain. Is that correct?
Yes.
Okay. And you're asking the court to approve this settlement as well today?
Yes.
Okay. Judge, I guess I haven't been sworn in, but I've met with the client. I've met with the children. I'm satisfied with the settlement, and I do believe it'll be in their best interest. And thank you to the attorney to reducing his fee so that the children could get more money in their pocket.
Okay, anything further?
One last, Your Honor. I have the documents before me to be executed by myself and Ms. Garcia. She has transportation problems. I will, as soon as she gets here this afternoon or tomorrow, I will execute everything and I will be filing them with court.
Okay, that's not a problem. The court, in light of what has been put on the record, is approving the agreement as testified to. And Ms. Thompson, have your fees been taken care of or has an agreement been reached?
Yes, ma'am.
Okay, great. All right, well then, Ms. Garcia, best of luck to you and your children. And I'm
Thank
glad
you.
that everything has worked out for you. And as soon as I get those documents, I'll sign off on them.
Thank you.
All right, anything else?
Nothing, Your Honor. May we be excused?
You certainly may.
Thank you, Your Honor.
You have a
Thank you.
blessed
Y'all
day.
have a good day.
Likewise.
Thank you.
Okay. Mr. Garcia?
Good morning, Your Honor, and good morning to everybody. I see.
Good morning,
Joe
Your Honor.
Yeah, and Frank Sabo out there. They've known them all my life, and I haven't seen him in a while. But yeah, Your Honor, we're here on number 37 and 38 on the docket, and I see Ms. Vasquez here, and we've got a status report. These cases have been mediated. On one of them, there's an outstanding mediator's proposal, and in another, we're waiting for a proposal on it. I would just request the court that we be given a DCC just in the meantime. I know that the trial dates are way off, but I have high hopes. Lisa and I work real well together, and hopefully we can get these things resolved.
Okay, let me call one case at a time then. That's so CL 192637-I, Sheila Maldonado et al. Versus Santa N. Cruz.
That's it. That's 37 on the docket, Your Honor. There's Bobby Garcia for the plaintiff.
Lisa Vasquez Garza, Your Honor, on behalf of the defendant. Good morning.
Good morning. Okay, so on this one, it has been mediated. Is this the one with the settlement, the mediator's proposal? I'm sorry.
This is the one where there's an outstanding proposal. It's the same mediator. He's done a great job, and he's got a proposal that he's sending over, from what I understand.
That
Okay.
is correct, Your Honor.
All right. So then if you're needing a DCC, go ahead and file your order setting the DCC and we'll get that set for you. And just so you know that trial settings obviously are not going to be for till next year.
Yes, ma'am.
Yes, Your Honor.
Okay. And so since you'll be filing a DCC, then we'll go ahead and follow the deadlines that'll be set forth in your DCO.
Yes, ma'am.
All right. The next one is CL 200927-I, Victor Manuel Flores Jr. versus Jeanne, Jeanne, Tonette, Tonette, Frederick.
That is correct, Your Honor. Bobby Garcia for the plaintiff.
Lisa Vasquez Garza, on behalf of the defendant, Your Honor.
Okay, and are you also requesting a DCC on this one?
Yes, ma'am.
Okay, then it'll be the same. Just go ahead and file your order setting the DCC and we'll get that done for you.
We shall do, Your Honor. Thank you very much. May we be excused?
Yes.
Thank
Thank you,
you.
Your Honor.
Have a
Thank
good day,
you.
everyone.
All right, Ms. Trevino?
Hi, good morning, Judge. Number 36 on your docket.
CO 183677-I, Eleobardo, Eleobardo Galaviz versus Star Operators, Inc. et al.
Yes, Judge. Nelda Trevino here on behalf of the defendant, Eliobardo Galaviz.
Joe Garcia, Your Honor, good morning on behalf of the defendants.
And Your Honor, on this one, we did decide to forego mediation. We are about 99% settled. I just need some time to work out a hospital lien. And opposing counsel has been very patient and very helpful with me on this particular case and on the settlement itself. I just need an additional time to get that lien worked out. So if I could please request from the court, maybe a 60 to 90 days, just to be on the safe side.
Okay, Mr. Garcia, anything to add?
No, Your Honor, she reported accurately on the current status. I have no objection in providing her the time that she needs. Judge, I just want to make sure that there are no other settings, scheduling orders in place or anything like that. And we're happy to sit tight and wait until she gets things resolved.
Okay, that I know of, no, but you all can return on April the 27th at 9:30. And hopefully you can get a response from them by then.
Okay, Judge. Thank you very much. Maybe I
You're
can
very
Your Honor,
welcome.
excuse?
Yes, sir. Yes, ma'am.
Thank you.
Thank you. All right, Mr. Reina?
Good morning, Judge. Number 34 on your docket.
Okay, CL 153093-I, Lurie, Lury Alejandro Duarte et al. Versus Jose Luis Soto et al.
Judge, I represent the defendant, Jose Soto et al. We were supposed to have mediated this case, Judge. We have not. There's been issues, I guess, with communications with opposing counsel and the mediator. They have asked to extend the deadline to mediate the case.
Well, Judge, I think just Sergio is here on behalf of the plaintiffs, Your Honor. The court had appointed Guerra Garza, and we've sent him email requesting dates. We didn't get any response, so I guess I was going to ask the court if they want us to continue to try to work with Mr. Garza to do the mediation, or can we appoint somebody else?
He hasn't responded to emails?
No, Your Honor.
Okay, before I change out the mediators, let me go ahead and have my office contact him to see if there's an issue. Perhaps, I don't know if he has any staffing problems but if there is an issue and he's no longer mediating or accepting mediations, then we will go ahead and appoint another mediator to you all.
Okay,
The other
Judge,
thing, Your Honor, if I may, I'm not sure that this case is going to settle. This is a family dispute over some real property.
Okay.
Would the court entertain a motion to waive mediation?
No, we're gonna go to mediation because that's what's required and that's what I require. And there's plenty of times that we've all gone into mediation saying there's no way we're gonna settle, and people come in with different moods. The mediator has a different way. Sometimes people are already tired of it and they want to get it done. So you never know. Maybe all the wind speed may be right outside and the air may have just given them a different attitude. So no, I won't waive mediation. Okay.
Okay, thank you.
All right. So then I'll go ahead and give you some time to do that. And then your next status will be April the 27th. If you need something sooner, let me know. And that'll be at 9:30.
Judge, do we just, I guess, Mr. Reina or myself, do we follow up with the court to see if they do make contact with the mediator, or if there's...
Ms. Rivera will contact you all as soon as she gets a hold of Mr. Garza and his staff. And if
Okay.
there's an issue and he's no longer going to be able to assist on this case, we'll get a new order sent out to you all.
Okay,
Thank you. Your Honor.
Okay, so if not, we'll see you all on April the 27th.
all right. Thank you, Judge. Maybe
Yes,
excuse.
sir. Yes,
Okay.
sir. Thank you. Okay, Mr. Graham?
Good morning, Your Honor. Taylor Graham, representing the Texas Department of Transportation on docket number, it's number 40 on your docket this morning, Your Honor. Cruz Carrizales Esquivel is the name of the plaintiff.
Okay, CL 21-1927-I. Cruz Carrizales, Carrizalez -Esquivel versus Texas Department of Transportation.
Good morning, Your Honor. Nick Moore here in the place of Gracie Orellana. Excuse me.
Okay, and what is the announcement?
Well, Your Honor, I think we've conducted the necessary discovery. I can't speak for Ms. Orellana or Mr. Moore, but they've served written discovery. We've conducted a deposition, and we have mediation scheduled 2 weeks from today. So.
Yes,
Okay.
Your Honor, this is just a status. I don't think I agree with the statement made by defense counsel there. So there's nothing else for us to announce.
Okay, so go ahead and come back on April the 27th and see how far along you all can get on this.
April 27th at 9 a.m., Your Honor?
9:30.
The 9:30. Thank you, Your Honor.
Thank you,
Okay,
Judge.
any other case? Anything else, Mr. Graham?
No, Your Honor, that's all. And if it's all from on your end, may we be excused?
Yes, sir.
Thank you.
Yes.
Thank you, Judge.
Yes, you're welcome. Okay, Mr. McLaughlin, you have, are you here on the default judgments?
I am, Your Honor, and if it's okay with you, I noticed that there's several family matters. If I could go last, I would greatly appreciate it.
Yes, that's not an issue. Let me go ahead and continue taking up the other matters.
Okay.
Thank you. Okay, Mr. Moore, you had another case?
Yes, Your Honor. I also have number 35 on the court's docket. It is going to be Noe Sosa versus Rafael Arredondo. Cause number CL-17-4211-I. This is the defendant's motion to reconsider, I believe their motion to compel written discovery that's previously been before the court.
Yeah, Judge, this is my case, my motion.
Okay, go ahead, Mr. Sabo.
Just for the record, Frank Sabo for the defendant. We're cause number CL-17-4211-I. It's our motion to reconsider the motion to compel. The motion to compel is in regards to a request for production for the plaintiff to produce the amounts that were paid to a healthcare provider arising out of treatment from a prior accident. The healthcare providers are the identical healthcare providers that the plaintiff saw following this accident, in a previous accident, and they resolved that case and settled the bills for an amount that we are seeking information regarding. The reason for the motion to reconsider the denial of the motion to compel is that the Texas Supreme Court wrote an opinion entitled K&L Auto Crushers back in 2021, in which the court made it abundantly clear that in that case, it was actually requesting the exact information regarding amounts that are billed and paid by others from the actual third party. In this case, we don't have any of that. Those two issues of seeking discovery from a third party, we don't have that. We're actually seeking discovery from the plaintiff themselves or himself. And we're not seeking information about anybody else. We're seeking information about the plaintiff himself, from the plaintiff himself. The Supreme Court made it very clear that the information, exactly what we're seeking, is relevant, and there are no privileges associated with that information, which was the basis for the denial of the motion to compel. Our request originally was a little broad, and I have agreed in the motion to narrow the request to the only information that we are seeking are documents reflecting the amount billed to and paid by the plaintiff to the two facilities, Open MRI of McAllen and 911 Pain Management, that the plaintiff was treated at following his accident that he was involved in March of 2016, that settled, resolved, and everyone was paid, which are two facilities identical, same treatment, same facility, same plaintiff, same lawyer, same everything, that he saw following our accident, which is the subject of this lawsuit. So K&L Auto Crushers made it very clear that information such as this, even broader, much broader than what we're seeking, is not privileged in any way and is relevant.
Okay, Mr. Moore, a response?
Yes, Your Honor. Just as far as what Mr. Tabo is saying, our request is that the discovery be limited to what is reasonably related and relevant. As long as the limitations set by this court are on just the plaintiff, the named plaintiff in this case, I would argue that the previous case is not relevant as far as the discovery is concerned, as every situation as far as reductions go is very case specific, context specific, but as far as the case law that Mr. Sabo proposes, I do see the case law he is referring to. But as it pertains to our client, Your Honor, we just ask that for all the production and discovery that Mr. Sabo would like to search through, we just request that the court impose that the cost and fees of acquiring all that information be imposed on the defendant.
This is a party, Judge.
Okay, so you don't have an issue in providing the information that Mr. Sabo is requesting as long as he pays for it?
Your Honor, I'm staying in for Gracie today, and this is my this is my instruction as far as what our position is. Furthermore, it's my position as well that if it's as limited as he's describing right now as just to our plaintiff versus other clients to get LOP information on those, the reductions relating to those, I would request that those be considered irrelevant. But as it pertains to just our client, as long as it's reasonably limited to that, we're not opposed on that basis.
Judge, all I'm asking for, I don't know in what form they would produce it. Probably the check, which is fine. A copy of the check that they sent to the Open MRI of McAllen facility and 911 Pain Management facility when they settled the lawsuit arising out of the March 2016 accident, along with the actual bill for the full amount that was charged, so that we can see what how they compare, so that we can apply the same ratios to this case as evidence of what is reasonable.
And Your Honor, let me clarify my statement earlier. If we have any of the records as Mr. Sabo described, just very specific, we're not going to withhold anything. We'll produce that. What I'm saying is, if there is anything that goes beyond that, whether it's requesting documents specifically from the entities or facilities themselves, that's what I meant by the onus being on the defendant. Otherwise, whatever we have, of course, full disclosure.
Okay,
They
so
were,
what I'm
they were his
hearing,
lawyers last time.
yes. And so what I'm hearing is just, it's not that, he's not asking for any of that. It's just a simple document as to just the billing statement, what was the reduction and the check or what have you. So it shouldn't be, I mean, you should have it in the file. I don't know how, I don't know if y'all are digital or what, but it shouldn't be difficult to get. So, okay,
Right.
then I don't think Mr. Sabo, or at least I'm not hearing that he's wanting anything more than what he just put on the record. So in light of what Mr. Sabo has said and Mr. Moore has said, that I'm going to grant defendants motion for reconsideration to compel that, and specifically as it's been set forth, and I read the motion, and the order seems to also, to also reflect that, correct? Oh, I don't have an order yet. I thought that's.
I don't remember if I prepared one or not, Judge.
No, sir. There's not an order on file, but if it mirrors exactly what you just said, there shouldn't be an issue.
I will make it do so, Judge, and send it to you.
All right. All right, then I'm gonna set a tickler for that for March the 18th. I know you'll probably have it sooner, but that's just for us to keep an eye on it.
Okay, thank you, Judge.
Okay, now after this, what is your next step?
I think once we get that's actually been the problem and what we've been asking for I want to say 2, but it may be 3 years. Once we get that, we will be in a position to mediate the case.
Okay, so let's come back on April the 27th, just to see where we're at 9:30.
April 27. Got it. Thank you.
Okay, thank you,
Your Honor,
gentlemen.
the tickler was March 18th, correct?
Yes, just to have the order submitted by March 18th, and it's just for me.
Okay, sure. Okay.
Nobody appears. It's just for our notes.
Thank you, Your Honor. Have a good
Okay,
day.
anything else?
Not
That's
for
it.
me.
Okay,
Thank you.
thank you. You have a good day.
You too. Thanks.
Okay. Mr. Dominguez?
Good morning, Your Honor. I'm here on number 33 on your docket for a status hearing on CL 14-1937I.
Okay, Maria Treviño et al. Versus Ricardo Garza Gonzalez et al. Mr. Peña? Can you hear me, Mr. Peña? I did see that somebody had been in there, but Mr. Peña, can you hear me? Oh, you're on mute.
Good morning, Your Honor. Now you can hear me.
Yes, sir. Okay. So
Maria Treviño, civil matter with Mr. Dominguez.
okay, and what is your announcement, counselor?
Judge, we get sealed in discovery. We'll need a pretrial, another pretrial in the 30 days maybe.
Okay,
Mr. Dominguez, do you want to add anything to the announcement?
Yeah, I'd like to add quite a bit, actually. Nothing has happened on this case except for actions that we have taken. The last status conference was November the 8th, and following that, 3 days later, we sent our initial disclosures, which is providing as much information as we could, as required by Rule 194, to Mr. Peña, and we have never received his initial disclosures. And then after that, we have proof of service that he got them on November 11th, the day we sent them by email. And then on January 18th of this year, we sent Mr. Peña interrogatories and requests for production to each plaintiff by email. And we have proof of service that he received them on January 18th. And so they were due on February 7th. They were due February 17th, and we've never received any answers or any responses to the interrogatories or requests for production. So as far as I can tell, Mr. Peña has done nothing, and we're the ones that have sent him some discovery and some discovery requests and no responses.
My three clients, Your Honor, are working on the discovery as we speak. They've been unavailable. I'll have them ready within 10 days.
Okay. Well, Mr. Dominguez, I guess if you don't get those in that time, you can file your motion to compel, and then we can see where we're
Right.
at that point. But so we can't even see whether mediation is even in the horizon at this point.
We can get a mediator appointed and go into, Your Honor. I'll have the discovery to Mr. Dominguez within a couple of days. They're working on them as we speak.
Well, the written discovery is just the beginning. Nothing has happened since 2014, when this lawsuit was filed for a 2013 collision. And
But you didn't appear. You didn't answer. You didn't appear until just recently, counsel.
well, I think it's improper for Mr. Peña to be talking to me directly, Your Honor. I'm talking to the court only. And
I'm sorry.
I think that,
I'm sorry.
And I believe that, as the court knows, this court inherited this case from a previous court, and in that previous court, nothing happened for 7 years. And so Mr. Peña is not actually prosecuting the case. He's not providing answers to discovery. And so I think that at this point, I think the court is correct that what we need is another status conference sometime in the near future. This case is nowhere near ready to mediate at all. We, the defendants, we have no idea what the story of the plaintiffs is, what the injuries, the alleged injuries of the plaintiffs are, anything. There's no information at all.
We will comply, Your Honor. We agree. The defendants had not answered with counsel, and we were about to take a default judgment until Mr. Dominguez came into the picture just recently. Just give us 10 days, Your Honor.
Well, let's go ahead and come back on April the 27th to see if whether or not that discovery has been answered and where we are at that point.
Thank you very much, Your Honor.
And then we'll see where we go from there.
At 9:30, Your Honor?
Yes, sir.
All right.
Thank you, Your Honor.
Maybe excused, Judge.
Yes, sir.
Thank you, Judge.
All right, Ms. De Luna?
Good morning, Your Honor. I have number 39 on your docket. On the other side is Fernando Lopez.
Okay, good morning, ma'am. CL 20-2838-I, Maria Obdulia, Obdulia Argandona, Argandona, versus Pilan Munoz et al. Okay, and what is your announcement, counselor?
On this case, we did file an agreed motion for continuance. We have attended mediation. We were pretty close at mediation. I think that we might be able to get this one resolved.
Okay, do you all have did the mediator give you all a proposal, or you're just continuing to talk on your own?
We did get a proposal. We rejected that proposal. However, we did get a new adjuster in, and I'm gonna see if they'll reevaluate that proposal.
Okay. So are you requesting then a new status conference?
Yes, Judge, or maybe a DCC just for a new trial.
Okay, if you want a DCC, go ahead and file an order setting the DCC and we'll get you set up. And then we'll go ahead and go with the deadlines on the DCO.
Thank you, Your Honor. I'll do that.
Okay, anything else?
That's all I have. May I be excused?
Yes, ma'am.
Thank you. Have a great day.
Likewise. Okay, Miss Serra?
Good morning, Your Honor. Karina Silva for Nereida Lopez Singletary. I'm here on number 42 on your docket.
Okay, F 4029-15-9 in the matter of the marriage of Judith Flores and Lamar Flores.
On this case, we're asking for a continuance at this time. This case is scheduled to be mediated on Friday, March 4th. However, our co-counsel in that case, Miss Kathy Alvarado, has had a death in the family, so she's asked to reschedule. So we're just asking for a continuance until we can get a new mediation date and mediate that case.
Okay, let's go ahead and do, I'm gonna set it for a status on April the 27th at 9:30. If anything happens before then and you need to get on the docket sooner, go ahead and just contact us and we'll go ahead and accommodate you.
Thank you so much, Your Honor.
You're welcome. Anything else?
No, that is all I have. May I please be excused?
Yes, ma'am. Take care.
Thank you. Have a good day.
You too. Okay, Mr. Flores? Attorney David Flores.
Good morning, Your Honor.
Good morning, sir.
I'm here on number 43 on the court civil docket. That's F607519-9. And we're here, a status hearing on the Beckwith matter.
Yes, sir. Were you making the announcement on your behalf and opposing counsel?
I have, no, Your Honor, we do have mediation scheduled for later this month, but I have not spoken to media or gotten authority to make an announcement by him for today's status.
Is that Mr. Caso on the other side?
Yes, Your Honor.
Okay. I don't know why it's not naming him on here. Okay, so when do you all go to mediation?
We had it scheduled for earlier this month. They have not complied with document requests. Because of that, we moved it to the end of this month. We're scheduling for, right now, we just got some dates from Roby Flores. So we're going to schedule that for, I believe, between the 21st and the 30th of this month. And so those are the dates that we just received yesterday afternoon from Mr. Flores, Roby Flores. But the only issue that we have is we want to make sure that, that they've been compelled to produce these documents, or there's been orders, and I've spoken to Mr. Caso and he's just telling me, I'll try to get them to you. I'll try to get them to you. This is necessary for us to finalize our evaluation in preparation for mediation.
Okay, then why don't we come back on April the 13th?
Very well.
At 9:30, and let's see if the mediation occurred, and if not, then we can take up any motions that you may have, or to kind of help get things going.
Very well, Judge. And that's at what time on the 13th?
At 9:30.
Thank you, Your Honor.
You're welcome, sir. Anything else?
I have nothing further, Your Honor. May I be excused?
You certainly may, sir.
Thank you, Honor. You have a wonderful day.
Thank you. Likewise.
Bye-bye.
Okay, Attorney Cantu del Bosque.
Good morning, Your Honor. How are you?
I'm doing well, ma'am. Yourself?
Good, thank you. Here on number 22 of your civil docket.
CL 210590-I, US Bank versus Sary, SARY Flores?
Yes, Your Honor.
Okay.
Your Honor, I was just recently retained on this matter. I did file an answer yesterday. It is set for a default today.
Okay. Let me see.
Your
Mr.
Honor,
McLaughlin, are you here on that one?
On that case.
Okay. So, all right, Ms. Cantu del Bosque, I'll give you an opportunity to contact Mr. McLaughlin.
Yes, Your Honor.
And we'll go ahead and set you all up for a status on April 27th at 9:30 to see if anything has been done.
Yes, Your Honor. If I can have a number for Mr. McLaughlin?
Yes, it's 512.
Yes.
339-4100.
Perfect. I'll contact you.
Thank you.
Thank you, Your Honor. Having no further business before this honorable court, may I be excused?
Yes.
Thank you. Have a wonderful day.
Thank you. Likewise.
Thank you.
All right, Mr. McLaughlin, I think we're ready with your cases.
Okay, Your Honor. The first one is number 2 on your docket.
Okay, CL 188648-I, Portfolio Recovery versus Elizabeth Garcia. Elizabeth Garcia, Elizabeth Garcia. Okay, the name being called out 3 times, no response, you may proceed.
In this case, we believe that she had opened up a My Best Buy credit card in November of 2015, making her last payment in November of 2016. The account was closed and charged off with a balance of $1,173.42. We're seeking that amount of damages plus costs to the court. I would ask court to take notice of the business records, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the service that was returned and has been on file for the required amount of time. No answer has been filed and the time has lapsed. Therefore, the court is granting the plaintiff's relief as requested on the record and set forth in the order that was filed on December 11th, 2018. And that's the one I'll ask to be forwarded to me. Okay, your next case.
The next case is number 3 on the docket.
Okay, CO 185733-I, Portfolio Recovery Associates versus Lucila Lucila Rodriguez.
Yes, Your Honor. In this case, we believe that the defendant had opened up a Amazon credit card in December of 2013, making their last payment on May 8th of 2017. The account was closed and charged off with a balance of $2,358.53. We're seeking that amount in damages plus costs to court. I would ask the court to take notice of and admit the business records affidavit, the non-military declaration, certificate of last known address, issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file. And specifically the service that was returned and has been on file with the court for the required amount of time. No answer has been filed and time has lapsed. The court is granting the relief as requested on the record for plaintiff and set forth in an order that was filed on October 4th, 2019. Okay.
The next case is number 4.
Okay, number 4, CL 192892-I, Crown Asset Management, LLC versus Marco Tapia.
In this case, we believe that the defendant had opened up a My Best Buy credit card in November of 2014, making his last payment in November of 2016. The account was closed and charged off with a balance of $1,633.25. We're seeking that amount in damages and would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the service that was returned and has been on file for the required amount of time. No answer has been filed on behalf of the defendant to date. Therefore, the court is granting the relief as requested by the plaintiff and put on the record and set forth in further detail in an order that was filed on June 23rd, 2021. Okay, next case.
Number 5.
CL 200622-I, US Bank National Association versus Bertha Cantu. Bertha Cantu, go ahead.
In this case, we believe that the defendant had opened up an account with US Bank on November 1st of 2011, making her last payment in November of 2018. The account was closed and charged off with a balance of $11,729.53. We're seeking that amount in damages plus costs to the court. Would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the service, the return of service that has been e-filed and on file with the court for the required amount of time. Let me see. And there is still no answer on file to date. The court is granting the relief as requested by plaintiff on the record and set forth in further detail in an order that was filed on December 27th, 2021. Okay, next case.
Number 7 on the docket.
CL 200651-I, Abraham Solis et al. Versus Jose Sanchez et al.
One moment.
Go ahead.
Judge, I believe the case that you called is number 6.
Oh, I'm sorry. What did he say? Number 7?
Yes, ma'am.
Oh, I'm sorry. Okay, CL 200856-I, Portfolio Recovery versus Bruce Bernal. Okay, go ahead.
In this case, Your Honor, we believe that the defendant had opened up a care credit account with Synchrony Bank. It was opened in December of 16 with the last payment on August 1st of 18. The account was closed and charged off with a balance of $2,777.65. We're seeking that amount in damages plus cost of court. We're asked court to take notice of the supporting documents and issue judgment for the plaintiff.
The court is taking judicial notice of all the documents in the court's file, specifically the service that was returned and has been on file for the required amount of time. No answer has been filed on behalf of the defendant, and the time has elapsed. The court is granting the relief as requested and put forth on the record by the plaintiff and set forth in further detail in an order that has been filed with the court on September 30th, 2020. Okay.
Number 8.
CL 21055-I, second round et al. Versus Horacio Guzman. The name being called out 3 times and no response. You may proceed.
In this case, we believe the defendant had opened up a pink credit card on February of 2016, making their last payment. On May 19th of 2018, the account was closed and charged off with a balance of $1,327.15. We're seeking that amount in damages plus cost of court. We're asking the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the service, the return of service that has been on file for the required amount of time. No answer has been filed on behalf of the defendant, and the time has lapsed. The court is granting the relief as requested by the plaintiff and set forth in further detail in an order that has been filed on August 3rd, 2020.
The next case is number 9.
CL 21058-I, second round sub LLC versus Elizabeth Loya. Go ahead.
In this case, we believe that she had opened up a community bank credit account on July 2014, making her last payment on June 7th of 2018. The account was closed and charged off with a balance of $2,348.88. We're seeking that amount in damages plus cost of court. We're going to ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file for the required amount of time. No answer has been filed to date on behalf of the defendant, and the time has now lapsed. The court is granting the relief as requested by the plaintiff and set forth in further detail in an order filed with the court on June 12th, 2020.
Next one is number 10.
CL 21585-I, U.S. Bank National Association versus Roy Castillo. Go ahead.
In this case, we believe that the defendant had opened up an Academy credit card with U.S. Bank on January 1st of 2015, making his last payment on June 3rd of 2019. Account was closed and charged off with a balance of $6,605.50. We're seeking that amount in damages plus costs to the court. Would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. No answer has been filed on behalf of the defendant, and the time has now lapsed. The court is granting the relief as requested by the plaintiff and set forth on the record, and it is set forth in further detail in an order that has been filed on October 21st, 2020. Oh, I'm sorry, no, that's not the order, that's the substitution. I do not see an order filed on this one.
I will have an order filed today.
Okay,
Judge, we're on number 10, correct?
yes. Do I see, am I missing it?
Yes, Judge, it was filed.
Where was it?
For
Where?
Roy Castillo, correct?
Yes.
Oh, I'm on the, I was on another, I guess I put in another court, a case number.
It's okay.
It wasn't even our court or something. All right, sorry about that. Okay, it is submitted. Okay.
All right,
Oh,
the next
you know
one is
what?
number 11.
That's the case I was on. Ms. Guerrero. Okay. CL 21653-I. Discover Bank versus Sylvia Guerrero. Sylvia Guerrero. Go ahead.
In this case, we believe that the defendant had opened up a Discover Bank credit account in June of 2013, making their last payment in November of 2017. The account was closed and charged off with a balance of $3,086.17. We're seeking damages in that amount plus costs to the court, and would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay. The court is taking judicial notice of all the documents in the court's files, specifically the service that was returned has been on file with the court for the required amount of time. And no answer has been filed on behalf of the defendant, and is granting the relief as requested by the plaintiff. Now, this one doesn't have an order. Or not that I see. I don't know, Ms. Rivera. Do you
No,
see?
Judge, you are correct, Your Honor.
Okay, this is the one I was looking at. This one doesn't have an order, Mr. McLaughlin.
I will make sure one is filed.
Okay. All right, your next case,
Number 12.
CL 201868-I, Portfolio Recovery versus Seda, SAIDA Garcia Castillo. Seda Garcia Castillo. Seda Garcia Castillo. Okay, no response, go ahead.
In this case, Your Honor, we believe that the defendant had opened up a Victoria's Secret credit card in July of 2016, making their last payment on February 14th of 2018. The account was closed and charged off with a balance of $1,141.89. We're seeking that amount in damages plus costs to the court, and would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
The court is taking judicial notice of all the documents in the court's file, specifically the service, the return of service that has been on file with the court for the required amount of time. No answer has been filed on behalf of the defendant, and the court is granting the relief as requested by the plaintiff on the record and set forth in further detail in an order that was filed on October 1st, 2020.
Your Honor, if I may have 5 minutes.
Sure. We'll take a 5-minute break. We're off the record.
All right, thank you.
Just let me know when you're ready, Mr. McLaughlin.
Yes, Your Honor. I believe we are on number 13.
Yes, let me just make sure my court reporter's ready.
Yes, Judge, ready.
Okay, go ahead. Then we're back on the record. Let me call CL 20-2043-I, Portfolio Recovery versus Norberto Becerra Jr. Norberto Becerra Jr. Norberto Becerra Jr. Go ahead.
In this case, we believe that the defendant had opened up a My Best Buy credit card in October of 2016, making their last payment on March 20th of 18. The account was closed and charged off with a balance of $3,370.77. We're seeking that amount of damages plus costs to the court. Would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
The court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file for the required amount of time. No answer has been filed on behalf of the defendant. The court is granting the relief as requested by the plaintiff that was put on the record and set forth in further detail in an order filed with the court on September 3rd, 2020.
The next case is number 14.
CL 23015-I, second round sub LLC versus Maricela T. Silva. Maricela Silva, Maricela Silva. Name being called out 3 times, no response. Go ahead.
In this case, we believe the defendant had opened up a Bell's credit card in November of 2010, making their last payment in August of 2018. The account was closed and charged off with a balance of $1,259.11. We're seeking that amount in damages plus costs to the court and would ask the court to take notice of supporting documents and issue judgment for the plaintiff.
The court is taking judicial notice of all the documents on the court's file, specifically the return of service that has been on file with the court for the required amount of time. No answer has been filed on behalf of the defendant and the time has lapsed. The court is granting the relief as requested on the record by plaintiff and set forth in more detail in an order that has been on file with the court since January 13th, 2021.
The next case is number 15.
PL 23486-I, Crown Asset Management LLC versus Laura Perez. Laura Perez, Laura Perez. Name being called out 3 times, no response. Go ahead.
In this case, we believe that they had opened up a Walmart credit card in November of 2016, making their last payment on August 1st of 2018. The account was closed and charged off with a balance of $1,860.34. We're seeking that amount in damages plus costs to the court. I would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. And no answer has been filed on behalf of the defendant and the time has lapsed. The court is granting the relief as requested on the record by the plaintiff. And there is no order filed, Mr. McLaughlin.
Okay, we will file an order.
Okay, your next case?
Number 16.
CL 203506-I, Crown Asset Management versus Fabian Esparza. Fabian Esparza, Fabian Esparza.
In this case, we believe that the defendant had opened up a web bank credit account in.
Oh, I'm sorry, Mr. McLaughlin. I need
Yes.
to recall CL 203486-I. There is not a motion for default judgment filed.
Yes, Your Honor. Well, we will correct that.
Okay, you're gonna need to file the motion for default judgment and another order setting hearing. So I'm gonna rescind. And so right now I'm gonna pass your motion for default judgment on CL 23486-I. And motion and order need to be filed. Okay, so go ahead on CL 203506-I, the defendant's name being called out 3 times and no response. Go ahead. You're on mute, Mr. McLaughlin.
Oh, sorry. So in this case, the defendant had opened up an account with WebBank, and they opened it in May of 2017. The account was closed and charged off due to non-payment with a balance of $6,349.40. We're seeking that amount of damages plus cost of the court, and would ask the court to take notice of the business records, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Okay. Let me the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. No answer has been filed on behalf of the defendant. The relief as requested by the plaintiff will be granted and is set forth in further detail in an order that has been on file with the court since January 11, 2021. Okay, your next case?
It's just the next one on the docket.
Okay, CL 210146-I, Crown Asset Management versus Esther Gallegos. Esther Gallegos. Esther is ESTHER, Gallegos, GALLEGOS. Okay, you may proceed.
In this case, we believe that the defendant had opened up a Victoria's Secret credit card on December 5th of 2010, making her last payment on May 7th of 2018. The account was closed and charged off with a balance of $1,539.69. We're seeking that amount in damages plus costs of the court. Would ask the court to take notice of the business records, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. The court there is no answer that has been filed on behalf of the defendant. The court is granting the relief as requested by plaintiff and put on the record, set forth in further detail in an order that was filed with the court on February 23rd, 2021.
The next case is number 18.
Okay, that's CL 210199-I, Crown Asset Management versus Ruben Martinez. Ruben Martinez, go ahead.
In this case, we believe that Mr. Martinez had opened up a Zales credit account with Community Bank on February 16th of 2018, making his last payment on May 10th of 2019. The account was closed and charged off with a balance of $3,547.37. We're seeking that amount in damages plus cost of court. Would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically, let me see, the return of service that has been on file with the court for the required amount of time. No answer has been filed on behalf of the defendant, and the time has lapsed. The court is granting the relief as requested by plaintiff on the record and set forth in further detail in an order that has been on file with the court since February 23rd, 2021.
Thank you, Your Honor. I would like to move to number 20. I want to check something. Number 20, yes. And check something before coming back to 19.
Sure. CL 210466-I, Discover Bank versus Ernesto Sosa Jr. Ernesto Sosa Jr. Okay, you may proceed.
In this case, we believe that the defendant had opened up an account with Discover Bank. They subsequently ceased payments, with their last payment being made on December 8th of 2019. The account was closed and charged off with a balance of $7,591.32. We're seeking that amount in damages plus costs to the court. Would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. To date, no answer has been filed by the defendant, and the time has now lapsed. And the court is granting the relief as requested by the plaintiff and set forth in further detail in an order that has been on file with the court since April 12th, 2021.
The next case is number 21.
CL 21-0572-I, Crown Asset Management versus Veronica Montemayor. Veronica Montemayor. Veronica Montemayor. Go ahead.
In this case, we believe that the defendant had opened up a Bell's credit account in August of 2012, making their last payment in August of 2019. The account was closed and charged off with a balance of $2,280. We're seeking that amount in damages plus costs to the court. Would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
The court is taking notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. No answer has been filed by the defendant, and the amount of time has lapsed. And the court is granting the relief as requested by the plaintiff that has been set forth on the record and is also set forth in further detail in an order that has been on file with the court.
Number 22. Number 22, we already spoke with Ms. Solis, and that was set for status on 4/27, I believe.
Okay.
Returning to number 19.
All right, returning to number 19, CL 21-0219-I. Jefferson Capital Systems versus Daniel Salas. Daniel Salas. Go ahead.
In this case, we believe the defendant had opened up a Finger Hut credit account. She made her last payment on October 27th of 2018. The account was closed and charged off with a balance of $977.98. We're seeking that amount in damages plus costs to the court, and would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. No answer has been filed on behalf of the defendant, and the time has now lapsed. The court is granting the relief as requested by the plaintiff and set forth on the record. And such relief is set forth in further detail in an order that has been filed with the court on April 15th, 2021.
The next case is number 23.
Okay, CL 21-0624-I, TD Auto Finance versus Jose H. Quintanilla Basurto et al. So Jose Quintanilla Basurto, Nancy Cruz. Jose Quintanilla Basurto, Nancy Cruz. Go ahead.
In this case, we believe that the defendants had entered into a motor vehicle retail installment contract on January 16th of 2019. They subsequently ceased payments, and the vehicle was repossessed with a deficiency of $29,499.03. We're seeking that amount in damages plus costs of the court. We would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. And no answer has been filed on behalf of the defendant to date. The relief as requested by the plaintiff on the record is granted and is also set forth in further detail in an order filed with the court on May 27th, 2021.
Next item is number 24.
Okay, CL 210635-I, TD Bank versus Maria Gutierrez. Maria Gutierrez. Go ahead.
In this case, we believe that the defendant had opened up a Target credit card in June of 2015, making their last payment in July of 2019. The account was closed and charged off with a balance of $1,130.47. We're seeking that amount in damages plus costs to the court. I would ask the court to take notice of the supporting documents in court's file and issue judgment for the plaintiff.
The court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. To date, no answer has been filed on behalf of the defendant, and the time has now lapsed. The court is granting the relief as requested by the plaintiff on the record and set forth in further detail in an order filed with the court on March 24th, 2021.
The next case is number 25.
CL 210659-I, TD Bank USA versus Navid, NAVID Alcala, ALCALA, Navid Alcala. Go ahead.
In this case, we believe the defendant had opened up a Target credit account in August of 2017, making their last payment in August of 2019. The account was closed and charged off with a balance of $2,844.67. We're seeking that amount in damages plus costs in court. I would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. No answer to date has been filed on behalf of the defendant and the time has lapsed. The court is granting the relief as requested by the plaintiff on the record and set forth in further detail in an order filed with the court on April 20th, 2021.
The next case is number 26.
CL 210753-I, Portfolio Recovery Associates versus Iridian Guerra. Iridian is IRIDIAN. Iridian Guerra. Go ahead.
In this case, we believe the defendant had opened up a Walmart credit card in August of 2015. They made their last payment on March 8th of 2018. The account was closed and charged off with a balance of $1,450.15. We're seeking that amount in damages plus costs of the court and would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
The court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. No answer has been filed on behalf of the defendant to date, and the time has now lapsed. And the court is granting the relief as requested by the plaintiff and set forth on the record, which is also in further detail in an order filed with the court on April 13th, 2021.
Next case is number 27.
Okay, CL 210762-I, Portfolio Recovery versus Laura M. Aguayo. Laura Aguayo, go ahead.
In this case, we believe the defendant had opened up a Bell's credit card on July 4th of 2009, making their last payment on January 10th of 2018. The account was closed and charged off with a balance of $733.16. We're seeking that amount in damages plus costs to the court. Would ask the court to take notice of the supporting documents in court's file and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. To date, no answer has been filed on behalf of the defendant. The court is granting the relief as requested by the plaintiff on the record and set forth in further detail in an order filed with the court on May 4th, 2021.
Number 28 on the docket.
Portfolio Recovery Associates versus Jose Hernandez Galvan. Jose Galvan, go ahead.
In this case, we believe that Mr. Galvan had opened up a Sam's Club credit card with Synchrony Bank on May 22nd of 2016, making his last payment on February 18th of 2018. The account was closed and charged off with a balance of $1,336.25. We're seeking that amount in damages plus costs to the court. Would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. No answer is on file to date by the defendant or on behalf of the defendant. And the court is granting the relief as requested by the plaintiff on the record and set forth in further detail in an order filed with the court on April 6, 2021.
The next case is number 29 on your docket.
CL 210952-I, Crown Asset Management versus Lisa Tamez. Lisa Tamez. Go ahead.
In this case, we believe the defendant had opened a First National Bank of Omaha Ram Dodge credit card in July of 2017, making their last payment in February of 2018. The account was closed and charged off with a balance of $2,293.90. We're seeking that amount in damages plus costs of the court. Would ask the court to take notice of the supporting documents in court's file and issue judgment for the plaintiff.
The court is taking judicial notice of all the documents in the court file, specifically the return of service that has been on file with the court for the required amount of time. There has been no answer filed on behalf of the defendant to date. The amount of time has lapsed. The court is granting the relief as requested on the record by plaintiff, and that is set forth in further detail in an order filed by the plaintiff on July 20th, 2021.
The next case is number 30 on your docket.
CL 211022-I, Portfolio Recovery versus Adam Medina. Adam Medina, go ahead.
In this case, we believe that the defendant had opened up a Torrid credit card on May 23rd of 2017, making their last payment on April 20th of 2018. The account was closed and charged off with a balance of $1,106.74. We're seeking that amount in damages plus costs of the court. I would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. The defendant has not filed an answer to date and the time has lapsed. The court is granting the relief as requested by the plaintiff on the record and set forth in further detail in an order filed with the court on April 14th, 2021.
Next case is number 31.
CL 211137-I, Portfolio Recovery Associates versus Teresa Herrera. Teresa Herrera. Okay, go ahead.
In this case, we believe that the defendant had opened up a Synchrony Bank credit account on February 2nd of 2011, making their last payment on January 16th of 2018. The account was closed and charged off with a balance of $1,079.45. We're seeking that amount in damages plus costs of the court. Would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file for the required amount of time. There has been no answer filed on behalf of the defendant to date. The court is granting the relief as requested by the plaintiff and put forth on the record, and that is set forth in further detail in an order that has been on file with the court on May 25th, 2021.
And the last one is number 32 on your docket.
CL 211261-I, second round sub versus Diana Ramirez. Diana Ramirez. Go ahead.
In this case, we believe the defendant had opened up a Bell's credit card on March 8th of 2014, making their last payment on October 18th of 2020. The account was closed and charged off with a balance of $1,540.15. We're seeking that amount in damages plus costs to the court. I would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
The court is taking judicial notice of all the documents in the court's file, specifically the return of service that has been on file with the court for the required amount of time. No answer has been filed on behalf of the the defendant. To date, the time has now lapsed. The court is granting the relief as requested by plaintiff on the record and is set forth in further detail in order that has been on file with the court since June 1st, 2021.
Thank you, Your Honor. That is all I have.
Okay. Thank you, Mr. McLaughlin. You have a good day.
You too, Your Honor. Take care.
Thank you. Likewise. Okay. Did anybody call in on number 6?
On number 6, Judge? No, Your Honor.
Okay, go ahead and set it for a drop.
Yes, ma'am.
And then, let's see.
On number 41, Your Honor, there were, I don't believe,
Well, they're set for at 11. I don't have anybody trying to get in.
no, Judge. So number 41, Judge, these parties are pro se. I did send the link to the email provided, but I don't believe that, I didn't get anything back rejecting the email, Judge.
Okay, go ahead and set that for a drop then.
And then for number 44, counsel did make contact with me this morning, Judge. He was in probate court and they were waiting to get heard or called on the record, and they're still there.
So do they have an announcement for this case?
He emailed me, Your Honor. Give me 1 second. He emailed me yesterday evening, Judge, stating that the respondent was still pending to get served.
Oh, so they still haven't served him.
That's correct, Judge.
Okay. Oh, let me see.
Judge, we do have a trial de novo in the afternoon. Would you like for me to send him that link?
No, because if the person has not been served yet, he'll probably request another 2 weeks.
Yes, ma'am.
So do we can do it on March 23rd at 11.
Okay, Judge.
Just let him know.
Yes,
The only
ma'am.
thing is he's gonna have to get a new citation issued for that
That's
date.
what I noticed. Yes, ma'am.
Okay, then that concludes this morning's docket. We are now off the record. Let me stop the live.